Hi, my name is Carl Pearson. I'm an attorney, and for the past 6 years I've been going into court to stop foreclosures and to reverse or even to vacate foreclosure sales. And the video that I have is called Stopping or Vacating a Foreclosure Sale. It's similar to another video, but I'm updating it and there's a lot of additional material here. Since the financial crisis starting in September 2008, there have been approximately 5 million families who have just lost their homes through foreclosure, with millions of additional families now behind on their mortgages who today are being threatened with the loss of their homes through foreclosure and sale. In most cases, there still are some legal proceedings that remain, and I spend most of my time trying to figure out for clients what they still can do, if anything, to save their property. To do this, I use my 50-plus years of litigation experience and the past 6 years of foreclosure defense litigation, and a continuing effort by me to develop and use new arguments in my efforts to save my clients' homes from foreclosure and sale and from being evicted from their homes. My level of experience in the foreclosure defense litigation scheme is rare, and I can help save homes anywhere in the United States working with a local attorney, but remember this, not in all cases. Please remember that. Each case is different and has to be considered individually. If you are one of the millions of families still threatened with foreclosure and sale of their home or investment property, I may be able to help you. Recently, I was retained to review a matter where the client is facing in 3 weeks an eviction proceeding to remove him and his family from his home. In 1 week, I reviewed the documents for a fee and wrote a report which I demonstrated had several new defenses and motions that should be asserted immediately to try to stop the sale, the eviction. The client retained me to do the work in a New York eviction proceeding. And I did this work, and 5 days later I obtained an order to show cause with a stay of the eviction proceeding, 3 days before the eviction was to occur. Please remember that each case is highly specific and your case may be totally different, and that I have to review the papers to see what the issues are and what can be done for you, if anything. This video explains what you could and should and can do, but I want to repeat that there are no guarantees that I or any other lawyer can give you. Many foreclosure issues remain unsettled. Judges will come to different results, even on the same facts. Clients may wait too long and lose whatever rights they may have to do something to help themselves. Clients also have much information about foreclosures, sometimes getting in the way of getting help. So this and many other problems exist. Most importantly, every case is unique and needs to be analyzed apart from all others. Remember that. The analysis should look at everything, most of which I'll list later, and include a review of everything which you or any of your attorneys have done or are still doing in any courts. This recommended analysis needs to be done by an attorney, such as myself, with substantial litigation experience during the past few years in defending against foreclosures, who keeps current on and even develops new foreclosure defense issues and strategies. I'll say at the outset that there don't appear to be many lawyers who qualify, and that's not good. And it is causing millions of homeowners to unnecessarily lose their homes. There are 3,300 state court systems in the United States governing the foreclosure process, and one for each of the 3,300 counties in the United States. My office is located in only one of those counties, and I don't believe I could find, through published foreclosure decisions, more than 20 to 30 lawyers in the United States who have the experience I believe is needed to do a good job in reviewing the record and recommending what, if anything, you can do and should do at this time to stop or reverse a foreclosure sale or to better defend a pending foreclosure action. But let's set that delicate attorney qualification matter aside, and let me explain what I recommend a homeowner-mortgagor should do to try to stop a threatened foreclosure sale of a home or investment property, even a commercial property. The threatened foreclosure is occurring for one or more of a variety of reasons, possibly including 1, You did not learn about the foreclosure proceeding because you were not served with any summons and complaint. 2, you were served and did nothing because you thought that since you haven't been paying your mortgage, you have no defense and didn't bother to defend. 3, you were negotiating with a bank or servicer for a loan modification agreement and thought that it was unnecessary to defend against the foreclosure because you were going to get a loan modification agreement that would end the foreclosure action, and why waste money that you don't have by hiring an attorney? You were tricked by the dual-track foreclosure process. 4, you even made payments to the bank on a trial modification only to find out that the bank refused to grant you a permanent loan modification after taking almost all of your money. 5, you hired a real estate or another inexperienced attorney to help you in a foreclosure mediation process to try to get you a loan modification, and this attorney did not bother to file any papers such as an answer in the foreclosure action, which is part of that dual-track foreclosure fraud problem. 6, you tried to defend pro se or in pro per, that is by yourself without an attorney, and you didn't know what to do, and the court rejected your efforts and awarded the bank or servicer a judgment of foreclosure and sale. 7, in a non-judicial state such as California or any of the other 27 non-judicial foreclosure states, you tried to get an order to show clause to block the sale, but you were not able to do so. 8, you or your attorneys have tried to raise the issue of lack of wet ink note or not in possession of note or lack of standing at the commencement of the action or evidence of robo-signed documents, but the court failed to act in your favor on those issues. 9, you did not move for reconsideration or re-argument to go up on appeal, and the time to do so has expired. 10, your attorney failed to protect your rights or tried to protect your rights and failed for whatever reason. 11, the court said that you failed to prove certain things or that you were missing something from your efforts to stop the foreclosure. 12, you were unable to vacate a default or other judgment and sale, possibly because you did not show excusable neglect, that is, excusable neglect, promptness after finding out about the default, or for failure to show a meritorious defense. 13, you tried to do a wrongful foreclosure action or a quiet title action and failed. 14, you tried bankruptcy and this didn't work either, and the bankruptcy was dismissed. 15, your attorney is involved in many areas of law such as negligence, divorces, bankruptcy, minor criminal matters, and is not keeping up to date on the most recent developments in foreclosure law. 16, your attorney does not try to create new defenses or issues in foreclosure cases and seems to do no more than look for what other lawyers have done in the past and doesn't know which lawyers to try to follow. Now, these are only some of the issues that I have to plow through when I review what has happened in the past, so I can make a report to my client as to what I think the client should now do to try to save his or her property, and taking into account the most recent decisions and newly asserted defenses and counterclaims by myself and other attorneys. To do this, I need the following documents. 1, a copy of the deed, note, and mortgage or deed of trust for the mortgage at issue, and any other mortgages on the property and any securitization audit prepared for you. 2, a copy of all recorded assignments of mortgage contained in the office of the recorder of the deeds for the county in which your mortgage property is located. 3, a written statement of all efforts that the homeowner-mortgagor made, directly or through others, to try to get a loan modification agreement or other relief such as a short sale, and all things that the mortgagor believes the bank did that were improper, in breach of contract, negligent, or illegal. 4, a copy of all documents used when applying for all loan modifications, whether by you, your attorney, or by a third person. 5, a list of index numbers for each foreclosure action commenced by as to the note and mortgage, and a copy of all documents from the court for each of such foreclosure actions, including the summons and complaint, all other pleadings, including your answer, if any, all motions, all decisions, all notices of appeal. In short, I need the whole record that has been before the court in each of such actions. 6, a statement of all bankruptcies filed with the court and index number for each of the persons on the note or mortgage or after the date of the note, or a statement that there have been no bankruptcies. 7, copies of all communications between you and the bank or servicer during the past 2 years, including any notices of assignment of mortgage at whatever time. 8. A copy of any qualified written request, QWR, that you may have made since the date of the note, and all responses by the bank, servicer, attorney, or other person to such QWR. 9. A statement by you of what transpired during any mediation, including the dates, who appeared, and what took place, to the best of your recollection, including any discussion of any type of relief, forbearance agreement, loan modification, short sale, deed in lieu of foreclosure, discounted payoff of a loan, purchase or sale of the defaulted note and mortgage, or whatever. Now, that is quite a lot of documentation to put together and for anyone to review. But if this is not done, you really cannot get the best advice on what you can do now, if anything. You will have to take time to put this together, and you should remember that time is your enemy. You may lose rights that you have through waiting to bring certain matters to the attention of the court. There are various deadlines for various types of relief you may seek, and without knowing today what you need, I'm not able to say what deadlines you have. Accordingly, you should act quickly in putting the documents together and retaining an attorney to review them for you. I'm assuming that you are dissatisfied with your past counsel, if any, rightly or wrongly. But if you are not dissatisfied, there is another problem. Perhaps your present attorney has missed a deadline or has failed to identify a way for you to get relief. In such a case, I would suggest that you should be having the review done by a totally different attorney. Now, either I or a totally different attorney could do a review and help you decide whether to keep your present attorney or suggest you replace the attorney with someone else, or have the reviewing attorney create proposed motion papers for use by your existing attorney, or for an attorney to be newly hired for this purpose of filing the needed motion. A problem is that an inexperienced attorney probably will be unable to know what he could have done, and may believe in good faith that he or she did everything that could be done for you. This is one of the most significant problems for homeowners, being represented by an attorney who does not have the requisite level of skills and experience to do this demanding foreclosure defense litigation work you need at this time to possibly save your home from foreclosure and sale, or to stop or reverse an existing sale and stop an eviction. It's all very complicated, as you can see, and it seems that the review should be done by a new attorney to decide whether the existing attorney needs to be assisted or replaced, which might of course depend on whether the existing attorney is willing or able to do what is to be recommended in the report. Anyway, I am willing to review the threatened foreclosure situation, wherever it may be, before sale, after sale, before eviction, or whatever, for a legal fee of $400 per hour, with a payment of $1,200 in advance, paid at the time of receipt of the needed documents. Please call me in advance to make sure that I have the time to do the review. My report will be writing, saying what you should do at this time, and will say that I am willing to assist for a legal fee of $400 per hour, whatever lawyer you may choose to use. Please note that my hourly rate keeps increasing and may be higher than the stated amount at a later date, while the time that I spend per case is decreasing because of this increased knowledge and experience that I've been obtaining. Many homeowners have a monthly payment between $700 and $4,000, which they haven't been paying, and for them, in an effort to try to save their home, the payment of $1,200 to a lawyer for 3 hours of his valuable time and his experience seems for most homeowners to be a reasonable expense, provided the attorney does know what he or she is doing. This is something you will have to decide, and whether or not you remain in your home may depend on your decision. It may be one of the most important decisions you are to make. You should look at some of my other videos to help you decide any questions you have about my qualifications. From my standpoint, I will tell you that I am willing to review your papers and propose and prepare a report, but I'm not anxious to do so. I have a lot of work to do with a heavy foreclosure litigation schedule, and only have so many hours each week in which to do this review and report type work. If you do not retain me, someone else will, to use my limited amount of available hours. As a result, I feel free in this video to tell you what you need to know, rather than try to sell you on something you don't need. Even in my report, I may say that you have a certain option, but that this option is not very likely to be granted by the court, if that's true. In cases like this, I tell the prospective client that I'm willing to do the work for an estimated amount an estimated dollar amount to be given, but if